Okay, everyone, we're back together again after a rude interruption, and I am sorry that I have to lecture this way, but who knows? Maybe it'll turn out pretty good. I'm looking at the camera right now, and I'm going to be using the PowerPoint that we have, the one on defamation, and so my eyes might be looking down for most of the time. At any rate, I think you can open up your defamation PowerPoint and then listen to me as we go along. So let's see what we can do here. Where we left off before the break was in the defenses against libel claims. We talked about what libel claims are and who can be libeled and that sort of thing. So we're going to get into what happens if you're sued for libel, basically. What is your defense? And there are 5 main defenses, as you can see on the PowerPoint: truth, opinion, fair comment and criticism, rhetorical hyperbole, and privilege. We're going to go into each one and talk about each and in what ways it is a defense. So we start with truth. There are examples of this, I think, on page 236 or so of our book. Truth is the best, as they say, honesty is the best policy. Truth is the best defense against a libel claim. A story need not be accurate in every detail. Courts expect minor inaccuracies to occur during reporting and therefore look for substantial truth. So if you wrote a story and it is substantially true, there aren't any obvious errors that seem to be there on purpose, that's probably going to be considered okay. By the same token, a truth defense will not stand if the individual facts are correct, but are combined in a manner that creates a false impression. We can libel through the omission of information. So we can err in an act of commission and in an act of omission. Remember that. So you can err in what you write, or you can err in what you leave out. Then the next one, opinion. It's a second defense against a libel claim. The Supreme Court has asserted, let me find myself again. I lost myself. Here we go. Supreme Court has asserted that a statement of opinion relating to matters of public concern, which does not contain a provably false factual connotation, will receive full constitutional protection. In other words, a statement that cannot be proved either true or false will be protected. Let's say you saw a Martian land in your backyard and you wrote about this and no one can prove it's false and no one can prove it's true. You're going to be protected because your statements must be believed in order to be found to be the truth. Going to the next, we have fair comment and criticism. This is something that some of you write blogs. Some of you write your opinion on blogs. Perhaps you have a restaurant rating site. If it's obvious that these comments that you write on your blog are your opinion or your critique, it is considered fair comment and fair criticism. So statements of opinion on matters of public interest also may be protected under this common law defense. The protection applies to comments supported by facts and made without malice, which convey an honest expression of the author's opinion. Such comments or criticism are not libelous unless they are written maliciously. And this is what we saw in the movie Absence of Malice. Megan wrote a piece about Paul Newman's character, Michael something or other, and she did not have any malice. She did not mean to hurt him. She did call him once. She really did not give him enough of a chance to respond to what she was writing, but there was clearly no malice intended. That was not the point of her writing. The fourth defense is rhetorical hyperbole. Remember, that's how it's pronounced, not hyperbole, it's hyperbole. Again, we have cases listed in our book, I believe on page 238. This is called exaggeration for effect. The theory is that a false statement must be believable before it can be considered defamation. Go back to the example about the Martian spaceship landing in your backyard. That's not believable. So it's a false statement, but it must be believable before it can be considered defamation. Rhetorical hyperbole applies to statements so extreme that no reader or listener could seriously consider them to be factual charges. These statements can even be in extremely poor taste. Then we go on to privilege, which is a little more difficult to understand. Again, we have cases on page 239 to 240. There is a certain level of privilege to make defamatory comments in pursuit of a legal, moral, or social duty. There are three kinds of privilege. 1, absolute. 2, fair reporting. And 3, here's my French for the day, neutral reportage. See if you can say it that well. Neutral reportage. Sorry about the phone ringing in the background. Nothing's perfect in your own home studio. Let's explain each of those three. So for absolute privilege, we've got an example of members of Congress are immunized against libel suits based on comments made on the floor of either the House of Representatives or the Senate. Also immune are public officials engaged in public proceedings. For example, judges on the bench, city council members during official meetings. This privilege also applies to public records from government agencies, legislative committee reports, and trial transcripts. Sometimes people let loose with a 4-letter or 5-letter or 6-letter word, or even more letters than that, and they don't mean to be crude or rude, but it's excused. It's not considered defamation. That's their privilege. And then as far as fair reporting is concerned, this protects those who report information from public records or proceedings later alleged to be defamatory. However, editors and writers must report information fairly and accurately. Again, do not include something that will mislead your audience to think something else. Excuse me. And the last, which is our French neutral reportage, these are accusations made by one prominent organization or public figure against another. 4 conditions must be met. A charge must be made by a responsible, prominent organization or individual. It must be a serious charge on a matter of public interest. Excuse me. It must be made against another public figure or organization, and the charge is reported accurately and disinterestedly. Disinterestedly does not mean that you're not interested in what you're saying or hearing. Disinterestedly means impartially, with no prejudice. So that is how we end our study of defamation. And I will end it right here. We're now at about 10 minutes and almost 30 seconds, and I will stop this right here.